Welcome to the Kids Caught in the Middle video series. Today's episode is on Chapter 12, Termination of Parental Rights. I'm Liisa Speaker and I read the book Kids Caught in the Middle, How Families Are Harmed When Judges Don't Follow the Law. Now, I said termination of parental rights, but really there's a whole series of child welfare proceedings that we cover in the book. And many of those points of those proceedings do involve an appeal by right, so that if a parent is unhappy with what has happened, they can appeal to a higher court. And every step of the process is so important to the parent-child relationship from the perspective of both the parent and the child. So even if there's not an appeal by right, it is important to that family. Removal is when the DHHS removes the child from the family's home because of allegations of abuse and neglect. Now, a lot of times these removal proceedings happen on an emergency basis, and then they're quickly followed by an evidentiary hearing within a few days, and it's a very quick process. But there are certain things the judge has to do in order to justify removal of the child from the home, and there's certain statutory findings. And if those findings are not made adequately, or there's not evidence to support what the judge did, there is an appeal by right available to the parent to challenge what the judge did. The next important phase of a child welfare proceeding is the adjudication. This is where the trial court decides whether there's enough evidence to take jurisdiction over the child. There has to be a preponderance of the evidence. And basically what it is the finding that the parent's not fit. And it's not a forever finding because the parent oftentimes is given an opportunity to remedy the situation. In fact, the DHHS is required to provide services to reunify the parent and the child unless there are aggravating circumstances. So we have this adjudication finding, and it could come about in a couple of different ways, actually 3 different ways. It could be by a plea by the parent, where the parent agrees that the allegations are true and, hey, I want to get help, let's get that help as fast as we can, and therefore I'm going to take a plea. Another way is by a bench trial. The judge has a whole trial on the adjudication, and remember, it's by a preponderance of the evidence. And third is really quite interesting because it's the only instance in a child welfare or family law case where there's a jury, because a parent can demand a jury trial for the adjudication and actually have a jury decide whether to adjudicate or not. Now, after the adjudication, the parent does have an appeal by right. So there is, like I said, another important step in the process, but there's more that's going to happen next. So after the adjudication, there's the services period of the case that happens in every case unless there are aggravated circumstances. And just as an example, aggravated circumstances is, for example, if a parent's different child has been murdered, or if there's been severe physical injury or torture of the child. So if statutorily defined aggravated circumstances exist, DHHS is not required to provide services, but in most cases they don't involve aggravated circumstances. So the parent gets services such as to help them with anger, drug addiction, housing, and all sorts of things to make it possible for them to raise their own child. But after all those services are provided, if the parent has not benefited from the services, DHHS can seek to terminate their parental rights. And there are many statutory grounds, over 13, upon which the DHHS can move. And the trial court only has to find one of the statutory grounds. The statutory grounds also apply in aggravated circumstances cases. So even though the parent does not get any services because of the aggravated circumstances, DHHS still has to show that at least one of the statutory grounds are met. And those statutory grounds have to be met by clear and convincing evidence. Now, once that has been proven by clear and convincing evidence, the case is not over because there still has to be a best interest analysis. So it moves to the best interest phase, which only has to be proven by the preponderance of the evidence that it's in the best interest of the child for termination of parental rights. And again, at the end of the termination phase, there is yet another appeal by right moment in the case. If you want to learn more about how to improve our laws, how to advocate and get other people to be more aware of how we need to fix our laws, you should click on the link below. That's my personal website, liisaspeaker.com, where I give all kinds of ideas of how to bring solutions about when there are failures in our family law and child welfare system.